All right, you're welcome to my banner. But quickly, there's an information that I want to share with you. Some 2,690 public sector salaries have been suspended over questionable payroll document. I'll bring you a lot more details on that. But right now, you can call it a law issue. You are just right on that. Now, when the state has a case against an individual or organization, a lawyer from the Attorney General's Department is appointed to take charge of the case and prosecute on behalf of the state. For some time now, the attitude of some state attorneys in prosecuting cases has been questioned. Some state attorneys have been accused of not attaching seriousness to cases they're given, or even worse, judges accuse them of undertaking shoddy or sloppy prosecution. So whose interests are state attorneys supposed to serve? This morning, we want to get some understanding of the role of state attorneys. We'll get some understanding of the Woyome case as well, and how we can get our 51 million Ghana cedis back. My guest is a legal practitioner. Alhassan Tampoli is my guest, my special guest. It's good to see you really in person. Thank you for joining me here on the show.
Thank you for having me.
Okay, so I want us to start the conversation this way. The state attorneys, are they, the prosecutors, are they the same as lawyers such as yourself, such as Egbert and Musa Ahmed? Are these the same people we're talking about here?
Well, but thank you very much, and then a very good morning to your viewers. The prosecutors at the Attorney General's Department, all of them at the Attorney General's Department are lawyers who have been called to the bar. Okay. Now, prosecution can be done on behalf of the Attorney General also by persons who are not lawyers. So oftentimes you have police officers in the courts prosecuting cases, but they have their threshold. So mostly everybody at the Attorney General's Department prosecuting cases on behalf of the Attorney General is a qualified legal practitioner, except those who are prosecuting minor offenses who are not, and mostly they are police prosecutors.
Okay, so from what you said, do we have enough of them?
Attorney General's Department, well, it looks like there is a shortage of personnel there. Even the regions are complaining because there tend to be more action in Accra to the detriment of the region. So I believe that, like many other public institutions, Attorney General's Department will not be the most resourced office, not least with the number of lawyers. Of course, the conditions of service have to attract people to go there. Yeah. But I do know, for instance, that people leave private practice to join the Attorney General's Department.
So they must be well motivated.
Somehow they should be reasonably well motivated.
Okay. So what is the problem there? Because why do they tend to lose cases? I mean, lawyers would definitely lose cases, but some of the cases, even the ordinary citizens think you shouldn't lose them because you have a lot on your plate. You could win this.
First of all, let me say that a lawyer is as good as his brief. So that the case that your client gives to you would determine sometimes how you are able to handle the case. So if you have an incurably bad case, now with all the legal ingenuity, it will be difficult for you to make any headway. Other times you have a very good case, and sometimes the lawyers can bungle the case. You understand? So we have these two situations. Now, in the case of the Attorney General's Department, one cannot be sure about the motivation. Sometimes the case is very bad, and they are given to the Attorney General's Department for them to handle. The mistakes would have been committed by whichever state institution that was handling the matter. So the Attorney General's Department comes in only to see if they are able to claw back something. Oftentimes it's very difficult because the case is already gone bad. Now, it will take a lot of effort for them to do something. Now, it becomes different when, in a clear-cut case, the Attorney General, state attorneys from the Attorney General Department routinely fail to show up in court, and those ones have been noted by a lot of judges. and they fail to come and prosecute their cases. And this morning we are even reading about some of them. Now, even when they show up in court, sometimes, and not all the time, sometimes they look ill-prepared. Now, I'll give you an example. During the trial of the alleged killers of the Yana, I used to go to the courts every day. Now, you could see that the defense counsel, for the counsel for the accused persons, Philip Addison at the time, and then Atachia, they frequent the courts every day. Now, the Attorney General Department sometimes comes in with different lawyers. So on one occasion, one lawyer shows up. On another occasion, another one shows up. Without the benefit of what transpired at the last sitting, it's difficult sometimes to follow track the trajectory of the case. So that what you yourself have put up at the last agenda date, you are putting another witness who is saying something different from what was said the last time. Now, without the benefit of knowing what was said before, it's difficult for the attorney in question to be able to track and then see how he guides the client or the witness to be consistent with their case. Now, that is another problem. I don't know, that could be a case management issue at the Attorney General Department for them to look at.
But are these not obvious things that should not be happening? I mean, shouldn't you know that if you have one person on a case or two people on the case, you should keep them on the case? Otherwise, they should brief whoever is taking over.
Precisely. That's the ideal thing. Normally what you do is to have attendance notes. So when you go to court, you make notes of whatever transpired in court. And then you put it on the file. Tomorrow when I'm not available and then you are asked to go to court, all you do is to review the attendance notes and you get the one of whatever took place at the last agenda. So you are able to take it from the next level. I don't know how the Attorney General...
Is it because it's a state institution? Because we have private legal practitioners who have got firms, and I am not sure that this happens.
Well, the argument can be made that because it's a state institution, sometimes people pay lackadaisical attention to matters of that nature. But I think that it is wrong, especially for an office like the Office of the Attorney General. It's one office. In fact, Attorney General is the only minister that is mentioned in the Constitution and Article 88. And then it's the only minister, for instance, who is supposed to be a lawyer. That is the only portfolio that you are required to have some professional background to have. You don't need to be a defense person to be a minister for defense or interior or foreign affairs. But for that position, so that some amount of seriousness is given to the Office of the Attorney General. And because of the work that they do for and on behalf of the state, I think that it should be the most serious state institution.
Shouldn't it be an indictment on the office, you know, for a judge to say that you did a sloppy job? I mean, even from where he said, he can feel that you did nothing. You didn't even want to win the case.
Yeah, that's one thing nobody can contest. The judges, when they are sitting on a case, apart from taking evidence and then trying the facts and then the law, they also take note of everything that transpires in courts, so that the demeanor of the witness is even something that the judge takes note of, whether or not to believe what he's saying. So apart from what you are saying, the way you handle yourself in the witness box will tell the judge what kind of person you are. How the lawyers even treat their cases also comes up for mention. And in this regard, it's just not the Attorney General Department that has come under the hammer of the judges. Even private legal practitioners who tend to do sloppy work are even chastised this way. So it's nothing new, but mostly the smoking gun points towards the Attorney General's Department, and they get mentioned for some of this sloppiness.
Okay, so you know, they are working for all of us. They're working for the state. So how do we get them to be on track? How do we can we get the attention when we speak? Do they hear? Can we tell them to be serious?
Yes, I think you can do so, and I believe some of these civil society institutions are making that effort. I believe Occupy Ghana has been making some strides in that regard with Auditor General's reports. And this morning I'm hearing that they have even brought an action against Dr. Otinyeji for
because we heard that he had been appointed as chairman of the GMPC.
So prior to that, he still had in his possession a vehicle that was supposed to be for his ministerial duties.
Yeah.
And whilst out of office, he still kept that vehicle. So some of these attempts can, I believe, claw back some of the things that we need to get back from the Attorney General Department.
You are a professional lawyer. When you're going through the process of becoming a lawyer, are you taught how to be private and how to be, when you're working for the state? Are there some ethics that you learn to practice with privately, and then some that you learn to use for the state?
I know where this question is coming from, but that's a very good question, though. At the law school, nobody is taught where you should go, whether private or public. Indeed, whilst we are at the law school, some people already know that they are going to the bench. They want to be judges. Some want to work in the corporate environment. They want to work in the banks, in corporate industry generally. Others want to work at the Attorney General's department. Some wants to do private practice. And the content of the law that we learn is the same, whether you want to work in any of these sectors. Whatever you study is the same thing that the person who wants to go to the bench studies. So essentially, there's no difference. And some of the guys who work at the Attorney General's department are some of the best in my class.
We don't
some of the people from my class who work at the Attorney General department were really, doing good.
We don't feel it.
So you never know. It probably is the institution that's making them tardy, but they were quite hardworking when we were in the law school. And so I don't want to believe that it is them. It is probably a question of the institutional arrangements that they have over there.
Because we've lost a lot of high-profile cases.
Maybe it's a matter of supervision as well. It's a matter of case management, because they tend to have a lot of cases to handle. So you find one attorney moving from one court to. It's the same with the private practitioner, but we tend to manage our cases, I believe, in a more efficient
Is it because you're relying on finishing the case so that you'll be paid and winning so that you get a lot more money?
Well, that is not the case. We cannot stampede the judicial process. We all go through the same judicial process. So there are timelines for whatever we do according to the rules of courts. So Attorney General doesn't have any shortcut. We don't have any shortcut as well. So when you file a writ, there's 8 days within which the defendant should enter an appearance, for instance. It applies across board. And when you file your appearance, you have 14 days within which to enter your defense. It cuts across. And the rules and procedure follow, and it applies to everybody. You understand? Now, for the Attorney General, they probably even have some concession. They never pay anything when they file stuff. Okay. Their professional practice licenses are not supposed to be renewed because they are working at the Attorney General Department. So some concessions are made to the attorneys who work at the Attorney General Department, unlike those of us who are in the private sector.
Because, I recall the Nayeli cocaine incidents and the fact that, is it that we didn't want to fight the case, or we thought we didn't have a case? But why do we start a process only to just give up in the middle?
Yes, sometimes you have to give up for genuine reasons. At the time of going to court, or at the time of charging the accused person, some facts or information available to you suggest that the accused person was probably culpable. And so on the basis of that information, the Attorney General will proceed to court. Now, if in the course of the trial, it emerges that the information that the Attorney General's department has is inadequate, or they were still relying on some other information which never comes true, the Attorney General's department, or indeed the Attorney General, has the power to control the judicial process, the trial process, by entering nolle prosequia.
What does that mean?
Now, nolle prosequia simply means we are no longer interested in the case. And that could be for some of these reasons. In their estimation, going forward, this case is not going good for us. So let's throw in the towel. And when you that the accused person is discharged, it still gives you an opportunity to come back with the same accused person if you get all the information that you need to prosecute successfully. And so the accused person is not acquitted, it's only discharged. Now, if the Attorney General still wants to discontinue with another process, there's what we call withdrawal. And by withdrawal, it operates basically like the nolle prosequia. You can withdraw at any time before judgment is given. Now, if the Attorney General withdraws a case in the process, or maybe let's say during the course of the trial, now the accused person will be discharged. Now, there is a technical difference between the nolle prosequia and the withdrawal. If the Attorney General finishes its case by calling all its witnesses and they have closed their case, and then they still withdraw, now the accused person will be acquitted and discharged because the full complement of their case has been made.
Okay.
And they still go ahead to withdraw. Now the accused person will be acquitted and discharged and can no longer be brought to court on the basis of those same facts.
Okay.
For nolle prosequia, they can enter nolle prosequia at any time before.
So you can decide to take the case on again another time when you think you have a lot more evidence.
Exactly. So that so they have the power to determine how they proceed. If they think that they don't have a good case, they have their liberty at any time to pull back, do reassessment of the merits of their case, and then they come back.
Okay.
So if you continue when you know that the strength of your case is weak, then you're wasting everybody's time. Especially when you do your own analysis and you see that the case is 50-50. Now, if the case is 50-50 for Attorney General Department, now remember that in the criminal case, the burden of proof is much higher. It's proof beyond reasonable doubt. And so that with 50-50 in your own assessment, you should know that it's not possible that you get a conviction.
So you should know before you even start the case.
You should weigh the case. And that's why you are the Attorney General. You are the #1 legal advisor to the government. You are the state's lawyer. So you are deemed to know the law so much so well that you can do an analysis of the strength of your case. You are not a novice like me, okay?
You're not a novice.
You're not a novice like me. So your assessment and your understanding of the law should tell you whether we should continue with this case or not. That is the work of the Attorney General, and it is exercised mostly by state attorneys on behalf of the Attorney General.
So I think what is also a little confusing is how one man can take somebody on behalf of the state and win a fine judgment at the Supreme Court, and the whole state, as powerful as the Attorney General is, and take the same case on in a different court and lose it like we lost it yesterday. How does it happen?
Well, like I said just a little while ago, for civil cases, and I believe you are talking about
I'm talking about the Supreme Court ruling.
Hamidu,
yes, Mr. Martin Hamidu, and the fact that
the Supreme Court.
Mr. Wilme has to return the 51 million.
So that was a civil case. And in civil cases, the burden of proof is on the preponderance of probabilities.
Okay.
So it is not reasonable, proof beyond a reasonable doubt. It is on the preponderance of probabilities. So it is not weighty. I mean, to prove that in a civil case is not as heavy as the proof.
Okay. So let me put it this way, because I don't have a law background. So I'm using logic here.
Yes.
If the person was not guilty of anything, the court would not have said return the money. So that's alone, there's some guilty or some offense there. I'm just thinking as a layman. Why would the other court not see the same thing that the earlier court had seen, considering that earlier court is even the highest court?
The highest court of the land. Well, I think that there's a bit of confusion in the minds of the general public about yesterday's decision. Like I said, there were two different cases. Yesterday's case involved the liberty of an individual. And so there's the need for the state to do more to prove that one, more than they have to do to prove in a civil case. In a civil case, you make your case and I make my case. The judge will weigh the two, and then they just decide that, oh, okay, we trust this one much better than you. So it's just believing the story of one side as against the other.
Are you saying that we didn't go with proper evidence?
But you see, this is how it works. In my understanding, I haven't had the benefit of reading the judgments that was delivered yesterday. But the snipers of information that we have read suggest that the judge took note of the fact that the prosecution itself did a very sloppy work. The relevant witnesses that they should have called, they never called. Now, the principal actors in the transaction, the Attorney General, the Deputy Attorney General, and then some officers who gave legal opinion on whether or not Mr. Woyome should be paid, were not called to come and give testimony in court.
Do you know why we will not call key witnesses as other persons may see them to be?
Well, in my practice, I would not call a witness whom I believe would do damage to my case. You understand? Now, I'm not sure if the Attorney General believed that those officers would do damage to their case. Of course, they were acting on behalf of the state. Now, it becomes tricky when, in your estimation, you believe that those officers still stand by what they said at the time that they signed off the money to be given to Mr. Woyome. So if they come and repeat that in courts, they can only strengthen Mr. Woyome's case.
Okay.
So you have to decide whether I should bring those officers or not.
Because this is my understanding also. If I came to tell you that I gave the money to him illegally, I'm also messing myself up.
Precisely. And the rule, there is rule of evidence which says that nobody can be compelled to self-incriminate. So I don't have to go and incriminate myself. So probably they didn't want to appear as witnesses, but what the Attorney General Department will be requesting them to do will be to go against what they have said previously. And we heard before by the Deputy Speaker of Parliament, First Deputy Speaker of Parliament, who was then Deputy Attorney General, who said that he believes strongly that Mr. Woyome was entitled to the money that was paid to him and that the state didn't have a good case. Now, what would Mr. Barton Odro be saying if he appears as witness for the prosecution? Is he going to say that, no, the man didn't have a good case?
No,
we
but
had a good case.
Okay, so how about the little details? If you say he was entitled to, I'm asking a few things around it, so that in the end, I also want to make an independent judgment and say, yes, truly, he was legitimately entitled to the money. How about just that? Just put me there. Let me repeat what I have told you, but let me add a lot more details, a lot more paper details, a lot more things that, you know, I probably did to arrive at that conclusion that he deserved the money. It was legitimate.
Well, that's a decision that the Attorney General had to make, and then I believe they decided against calling those witnesses. On the other hand, Mr. Woyome could have called them as witnesses and say that these are the people who gave me the money, they signed off the money, and they can come and then testify to why the money was given to me. Of course, he relied heavily, from what we said, we read yesterday, that he relied heavily on correspondence between the Attorney General at the time, Mrs. Betty Mol Idrisu, and Dr. Kovna Dufo, who was the Minister for Finance
at the time.
Rely on that advice. So they advised the Minister of Finance to pay the money. So he believed.
So let me flip the coin. He won this case at the High Court.
He did.
Can he fight the judgments that the Supreme Court gave them?
You said before that the Supreme Court is the highest court of the land. And then in the only appeal that is open to him is to go for a review. Now, review jurisdiction is not exercised lightly. You have to come on the basis of some exceptional things that the court didn't consider at the time that they gave their judgment. So I don't know what it is that will be exceptional now. That wasn't then. I believe all the case that Mr. Woyomi had to make at the Supreme Court had been made, and the judges considered the strength of his case, and they gave their judgment. Now, he can only go for a review, and there's a time limit for invoking such appeal processes. I believe the time has elapsed.
Okay.
And so he's barred from even inviting the Supreme Court to review his own decision. So what it is Mr. Woyomi is supposed to pay the state 51 million Ghana cedis that was given to him, and that is non-negotiable.
So when a judgment of the sort is made by the Supreme Court, when is he supposed to be returning the money?
It is the duty of the Attorney General to initiate processes to recover the money. So when in civil cases I go and obtain judgments, the court doesn't have to do anything again. I have to do the rest.
Okay, but so if the Attorney General is not acting, what happens?
The Attorney General, unfortunately, is the only officer who is supposed to do this. And they were directed to initiate processes to recover the money.
Is it so hard a task to do? Because for me, if you ask me, I would say that the Supreme Court did the hardest job by making the judgments. All you have to do is to go for the money, and the person is not paying the money. You can take the person on again. Yeah, you can go back to the court and say you said this, but he's not giving me the money.
There are procedures, and I believe the Attorney General's department knows it more than anybody else. When you get judgments, you enter judgments, and then you initiate the recovery process. So the rules are very clear what to do, and then get your money back. Nobody wants to give the Attorney General's department any lecture on that. I believe they know what to do. Failure to do so will be for other considerations, but not because the rules do not allow them to do so.
From where you sit, the Supreme Court ruling and this High Court ruling yesterday, would you say the Supreme Court ruling was based on emotions or what the people, were thinking at the time? Because if you cannot use those evidence there to fight this in this other court, or if it wasn't based on hardcore evidence.
You see, in the Supreme Court, the case before the Supreme Court, even though the facts are the same, but the nuances are a little different from this particular one. Now, the Supreme Court said, for instance, that the purported contract that was entered between Woyomi and then the government was unlawful. It was an illegal contract. And for that matter, any rights that accrue under the contract should be reversed. And so whatever money that have been paid to Mr. Woyomi should be returned to the state. Now, in the criminal trial, Mr. Woyomi was charged on 2 counts: defrauding by false pretenses and 2, causing financial loss to the state. Now, defrauding by false pretense, how do you prove defrauding by false pretense?
The earlier court had said something illegal there.
The Supreme Court?
Yes.
The Supreme Court said the contract was illegal.
Yes.
Okay,
so isn't unlawful. That false pretense?
No, but this is how false pretenses work. I mean, you have to look at this case separately. Let me give you the chronology of events. Mr. Woyomi comes to the Attorney General's department, says that I had a contract with the state, and then the state abrogated the contract. I was entitled to be paid some compensation, and even under the contract itself, I was entitled to some commission. Those monies have not been paid, and the state takes process. What's it called? Enters into a consent judgment on the basis of what Mr. Woyomi submitted to the Attorney General Department. They entered into a consent judgment, and it was filed in court. The court endorsed the consent judgment and said that pay the man 14 million Ghana cedis. And it also requested Mr. Woyomi to pay some deposits in court, so that in the event that he doesn't win the case, he will pay back the money. The money will be used. And if he wins, the remaining 2 installments will be given to him. Now, this is what the Attorney General Department did. The Attorney General Department paid all the money to Mr. Woyomi, based, of course, on the information available to it. Now, but
that's not what the court had said.
That's not what the court said.
Okay.
Now, it emerges somehow and the Attorney General had come to the realization that no, the money was wrongly paid to Mr. Woyomi. Now, the rules of court again allows you to go and set aside the consent judgments. They didn't do that. You understand? You're supposed to set aside the consent judgment and then recover the money that has been paid to Mr.
Okay, so
Woyomi.
that consent judgment would have been what exactly?
So what the consent judgment would have been vacated. We said that on the basis of the information that we have seen, that there is no contract with Mr. Woyomi, we paid him the money on the mistaken belief that he was entitled to the money and that there was an existing contract. We believe that such a contract does not exist, and the courts should strike out that judgment. Now, they can do that. They never did that. The next thing you come and then you say that you've been defrauded by false pretenses. You understand, and you take the man to court. How do you prove defrauding by false pretenses? That there has been some misrepresentation of facts by the accused person to you, and that you relied on that misrepresentation, and that you suffered financial losses as a result of the misrepresentation. Now, based on the chronology of events, I'm not sure how the Attorney General Department can say that they have been given some misrepresentation by Mr. Woyomi. They did legal opinion upon legal opinion. The head of legal at the Ministry of Finance gave a legal opinion on the payment to Mr. Woyomi. One other chief state attorney at the Attorney General Department did a legal opinion, and the Deputy Attorney General at the time also did a legal opinion based on the available facts and the relevant documents. So how can you tell me that, and Mr. Woyomi has been consistent all along. He says that I do not have a contract with the state. And he has said it right from the first interview that he granted all the way until he was charged before the court.
So, listening to you narrate, shouldn't these people be standing trial instead?
I believe those
because
who have caused financial loss
to us?
Precisely. So now it's for you to judge. Who, between the two, who has caused financial loss to the state?
Amazing.
Is
it you, Al-Hassan, who is confusing me? Or if we had a second lawyer, the person would have a different opinion from what you've just shared?
Well, somebody can have a different opinion from what I said, but these are the hardcore facts. I mean, the chronology of events, I didn't create them. I'm only recounting what has happened right from the beginning till now. Now, based on the chronology of events, I believe Mr. Woyomi cannot be charged for defrauding by false pretenses. I mean, the case was dead on arrival, as far as I'm concerned.
But we didn't know?
Well, they had to do something. You have paid the money
mean,
to
what
the
is
man.
Do something?
The furore.
I said this morning that what's the point in going to courts and asking for the person to be jailed when you've been asked to retrieve some money? Why don't you just concentrate on that and get us our money?
Well, I guess the reason for probably sending Mr. Woyomi to court is a reaction to the furore and indignation that has characterized the whole Woyomi saga. So the public was up in arms and something had to be done. They had to go to court. Now, notwithstanding the fact that they had done things one way or the other to facilitate the process, they come to court. And so you cannot, open your eyes, enter into an agreement with me. I give you all the facts. I tell you this is what I don't have a contract. And you still go ahead and give me money and you come and plead defrauding by false pretenses.
I see your point. But now we're contemplating whether to appeal the decision yesterday or not. From what you've said, it means that we don't have a case. We don't even have to go on appeal.
Well,
can we change the story? The
Attorney General has said that she is going to, she has applied
She's
for
going
a
to
copy
study.
of them, and she will study. And then I recall Mrs. Betty Molidisu said the same thing when the Yana judgment was given. Immediately she said that she has requested for a copy of the ruling, and then she's going to appeal. She's going to study and she will appeal. To date, I don't know what's happening, so I don't think.
So is it just a political statement?
I don't know if it's just a mere rhetoric or the Attorney General is a honourable woman. I believe she would not be making such rhetorical comments.
But can I ask you, is it the influence of politics that is making the work of the department difficult, or that is preventing them from winning cases, or losing the ones that we expect them to win?
Don't forget that the Attorney General is a political animal. I mean, the office is a political office, and is a Minister of State. and all that. So I believe that there could be some consideration other than the legal. That is my belief. I may be wrong, but there could be considerations other than legal.
Should we be advocating for that to be, a separate institution altogether? It shouldn't be a minister of state who is appointed by the president, for instance.
Yeah, the argument has been made severally. I believe even the Constitutional Review has considered some of these inputs to decouple the office of the Attorney General from the Minister of Justice. The Minister of Justice will concentrate on being the government's official legal advisor, and the Attorney General will become more like an independent prosecutor.
Yeah, so like a professional, somebody who wants to take on cases, for love of the state, get the state back the things that have been taken away from it.
Well,
and if we don't have a case and we genuinely have to withdraw or say we don't want to go on, then we do that.
Precisely. So the argument, I'm sure, will still be made whether we should still decouple the office of the Attorney General from the Minister of Justice because of some of these perceptions. I believe but somebody will have to appoint the Attorney General anyway, or the public prosecutor anyway. It's going to be the politician. We have institutions, independent commissions in existence right now. Now, we don't know whether on the basis of their independence they have delivered up to the mandate that has been given to them. So
good point.
So that can be the starting point of the discussion. Let's look at what we already have, the independent commissions. What is their impacts? Even though the chairpersons cannot be removed by the fiat of the government or the president, what have they done? What is the impact of those offices?
Yeah, and I'm thinking Shraj right now. I mean, the moment you say what has been their impact, I'm just thinking Shraj. But I won't take you to Shraj, don't worry.
That is your example. I didn't say it, so that is your own example.
But, a lot of people have said a lot of things because, sometimes we don't properly understand the issues and then we start tagging people. Some people have described Mr. Woyome as a thief, people, feeling that he's guilty for something. The fact that he owes us, or he has to refund us that 51 million Ghana cedis, can we then conclude that he's stealing our money?
Well, the courts yesterday, on the basis of the decision that they gave, remember that Mr. Woyome was not charged for stealing. Now, the offense of stealing can be established when you say somebody has dishonestly appropriated something that does not belong to him. You understand? Mr. Woyome was not charged for stealing. He was charged for defrauding by false pretenses and then causing financial loss. Now, whether or not we can call Mr. Woyome a thief is debatable because he wasn't charged for stealing, so we can't say whether he is a thief on the basis of the fact that he wasn't charged for stealing. You understand?
But the Supreme Court ruling...
The effect of the decision of the court yesterday is that Mr. Woyome is not guilty of defrauding by false pretenses and that he got the money genuinely.
If you were Mr. Woyome's lawyer, would you be taking the people who were tagging him, who were calling him a thief on illegal action against those people?
There's... he can come on the basis of what's the name? Of defamation, libel and all that, and slander, because there have been publications, there have been words used in the electronic media and all that. But there are defenses to those two. There are defenses to those actions. So if on the basis of the information available to me, I believe strongly that Mr. Woyome has indeed taken the money illegally, or on the basis of the decision of the Supreme Court, I see that Mr. Woyome is a thief. I think there is a basis for people to do so because of the decision of the Supreme Court. So there is a defense of truth. Okay, so they can say that yes, what we said is true, and that is why we say you are a thief. And so that's a defense that they can, or a fair comment. So there's also a defense of fair comment.
So if we don't, is there a certain time frame within which we have to appeal if we want to?
Yes, we have.
After which we cannot?
Yeah, we have to do so within 3 months.
Within 3 months of the ruling, so starting yesterday or today.
So when they get the copy of the ruling, I believe they will study, and then whatever they have to do, they must do so within 3 months.
Okay, and then if they don't
do, there's another window of opportunity. That's about 6 months, and if they have to come between 3 months and 6 months, they must do so. They must demonstrate exceptional situation that has made it impossible for them to come within the 3 months.
Okay.
But mostly it's within 3 months.
But if they don't do anything at all, and this 3 months, this exceptional 6 months window that you also gave, if we don't take advantage of that as well, then what becomes of this whole Woyome case?
Mr. Woyome will not be our guest at Nsawam.
Can we try him again?
There's something we call Otrifwa acquit, double jeopardy. The man has already been tried and he has been acquitted and discharged. And so on the basis of those same facts, from that same transaction, you can't bring Mr. Woyome to court forever and ever.
So can I confidently say that after a year or after 6 months, if we do not appeal, we don't do anything, the case is dead?
Our right to appeal will be completely extinguished, and Mr. Woyome will no longer have any apprehension whether he will be brought before the Court of Appeal or not.
Is it true?
Facts.
Is it true that Mr. Woyome could say that I will pay you your 51 million, except that I don't have it to pay right now? I can pay 50 Ghana cedis, for instance, every month.
They can enter into some sort of agreement with him to pay by installment, and they must factor in interest and the going rate. If it is a judgment that I have obtained for my clients, I will make sure I will go for it up to the last pesos. So I do not think that Attorney General has to give us something.
Is there a time frame within which he has to pay us back this money?
Well, that has to be determined by the court, but there's no timelines. I mean, they can go for his movable and immovable. They can impound his bank account. They can garnish his bank accounts. Okay, they can attach his immovable properties. If he has houses, and I believe he has some houses in Trasaco and all that, so and that's the information available to me. So they can go for all of them.
Okay, so they can use that to offset this.
They can go for all of them to offset. If they don't get enough, then that is probably what they can get. And if the man doesn't have the money anymore, you can't do much. But you can go for anything, including his clothing. Go for everything.
But can you jail him for his refusal to pay you back the money?
Well, you don't go to prison on the basis of the fact that in a civil action you failed to pay. It used to be the case, but the rules have changed. You can no longer take anybody to prison on the basis of the fact that they have not behaved as judgment debtors to pay up their obligations under the judgment that has been given against them.
So we've been saying this 51 for a long time. Is it still 51, or when we are taking it back?
It should attract interest. It should attract
Who
interest.
determines that?
At the commercial rate. So I believe the judgment of the Supreme Court will clarify that. I haven't seen it right now, but I believe normally we will say that at the time of entry of judgment, or at the time from the time the money was given to him to the date of final payment or the date of judgment. So it depends on the tenor of the language that the Supreme Court used.
Do you think we're serious in wanting our 51 million?
I want to believe we are.
Do you see, in terms of execution, do you see our seriousness?
I haven't followed the level to which the Attorney General Department has reached as far as recovery of those monies are concerned. But I want to believe that they will do nothing but to recover the money. To not do that would be simply atrocious. And it will be an indictment on the department and the person of the Attorney General for a former Attorney General to obtain judgments on behalf of the states. And all you have to do is to recover the money back. And if you haven't recovered 1 cedi at this time, it will be simply unbelievable.
This must be really disappointing for Mr. Amido, who started the process. Or, this second action he doesn't really care about it. What he wanted to do is what he achieved.
Was to save the state from losing those monies. Well, Mr. Amatamido cannot be second guessed. I believe by now he should have issued a statement.
No, he has decided not to talk.
So I believe by now he would have been writing, or he probably has released some whilst we are in the studio. I'm sure.
But what should this, whole case, particularly the judgment yesterday, what is the thing that the message that it's sending to Ghanaians?
Well, first of all, it's sending the message of rule of law, that anybody, no matter who you are, would have your day in court. So if the state has anything against you, they bring you to court, number one. Number two, it also says that if the case is brought against you in court, the obligation of the Attorney General's Department to prosecute the case diligently cannot be overemphasized. I mean, they have to do the case and then show more commitment to the way and manner that they do the case. Thirdly, if you are prosecuting a case like this, you have to study on the basis of the evidence available to you. And you study the chronology of the case and make a determination whether on the basis of the facts that I have a good case. So you have to make that assessment seriously before you come to court. Many people believe that this case will go nowhere. And so yesterday, simply were just vindicated.
I'm just surprised that if ordinary people see that this case is not going to go anywhere, and then the legal brains, the state legal brains from where they sit, they should even be seen better, and they think they have a case.
Precisely.
It just amazes me. Well,
it amazes me as well.
I want to say thank you for your time.
I thank you very much.
Really grateful for taking us to courts. I have come out with a better understanding of the issues. Thank you.
You're most welcome.
Hassan Tamponi, a legal practitioner, joining me and educating all of us. I hope that you had your fair share. It's been quiet in the studio, which means we have some lawyers coming up, cameramen / lawyers pretty soon. Stay with us here on the AM show. We still have got a lot more for you.